Good afternoon, everyone. Welcome to the next of our Essential series. These are topical, engaging, and technical webinars on wealth and wellness by leaders in the private client world. I'm Lottie, founder of the Jura Society network and private client consultancy, focusing on women, wealth, and well-being. This afternoon, I'm welcoming Alexandra and me from Kingsley Napley to share an overview on how to protect and pursue business interests during marriage and divorce. Please ask any questions in the chat, and we'll have time for Q&A at the end. The session will also be recorded, so anybody who's watching this later on, please do enjoy and get in touch if you do have any questions following this. Now I'm going to pass you over to Alex and May, and I will see you shortly.
Great, thanks, Lottie, and it's great to be invited to speak at the Essential series. My name's Alexandra. I'm a senior associate here in the family team at Kingsley Napley. And this is my colleague May, who is an associate in the corporate and commercial team here at KN as well. If we could upload the slides, start that, great. So May and I are going to discuss today some points to consider in respect of business assets when entering into a marriage or during a marriage before a potential marriage breakdown through the preparation of a nuptial agreement, either entered into pre-marriage, known as a prenuptial agreement, or during the marriage, which is known as a post-nuptial agreement. And then May is going to speak about how to protect such assets from a corporate and commercial perspective. And then we will go on to talk about how business assets are potentially pursued upon a marriage breakdown in the context of financial remedy proceedings, when there isn't necessarily a nuptial agreement in place, and also some strategic points to consider from both a corporate and family law perspective, as well as the approach of the English family court. And then hopefully at the end, we'll have time for some questions. Great, let's get the slides up. Perfect. So if you own a business, either together with your spouse or business partner or solely, it's likely to form a key part of your assets, requiring protection in the unfortunate event of a marriage breakdown. And as I mentioned, this is often done by way of a nuptial agreement. So what are they? These are written agreements that seek to protect existing and future assets in the event of a marriage breakdown, and to try and regulate how a couple's financial resources should be divided with a view to avoiding litigation in the future. And although at the moment there is no Act of Parliament in England and Wales that make these types of agreements legally binding, the courts do follow case law, and there is now good law to say that a nuptial agreement will be binding if certain factors are adhered to. For example, both parties need to understand what they're signing and have received independent legal advice. They need to enter the agreement freely and under no duress. There needs to have been an adequate exchange of financial disclosure, as well as a decent interval between signing the agreement and the wedding date. And then perhaps most importantly, the agreement mustn't leave the financially weaker spouse in a predicament of real need while the other is comfortably provided for. So the court will always retain jurisdiction to consider whether the terms of a nuptial agreement are fair or unfair, and they can go behind it if they do think it's unfair to the financially weaker party. So what can be included in these nuptial agreements? Well, in the context of seeking to protect business assets, it's important to include a clear definition of what should be considered separate property, to be ring-fenced and kept free from any claim from the other party during divorce, and what might be considered joint property to be shared equally. So the property can include company shares, any income from the business or accumulated income, or indeed the passive growth of a business. So the definition of separate property and what should be incorporated into that is often a point that's negotiated between the parties. And as I mentioned before, it's very important that there is adequate financial disclosure when entering into these agreements. And that will include providing a valuation of the business at the time of entering into it. So this is because the financially weaker party needs to know what they might be potentially giving up by entering into the agreement. So it's in the interests of the business owner to disclose the full value pre-marriage to maximise what is going to be protected. And then in terms of some of the risks, well, a nuptial agreement needs to ensure that the financially weaker party is not left in a predicament of real need. So if one's to challenge the agreement, a party needs to show that their needs are not met by the provision under the agreement, or that there were factors prevailing at the time that now render it invalid. So, for example, if one of the parties didn't adequately disclose. And this is very important to consider when drafting the provisions to try and make the agreement as watertight as possible and to prevent any court intervention at a later date. So, if one party's business is considered separate property and that is one of the party's main assets, it's important to consider how a financially weaker party's financial needs might be met from other non-business resources. But it may well be that a provision should be included, and it would be fair to include allowance for the other party to share in a business asset or to share in any profits up to a certain cap, to ensure that their reasonable needs would be met. I'm now going to hand over to May, who will talk about it from a bit of a more corporate commercial perspective.
Hi, so from a corporate perspective, you'll be looking to protect your interests through a shareholders agreement, which is essentially a private contract governing the relationship between shareholders in the company and the company itself. And then the Articles of Association, which are a set of rules that are made publicly available governing the internal affairs of the company. All private limited companies are required to have Articles of Association, and if bespoke articles aren't prepared, the default model articles will apply. And these will set out the most basic provisions in relation to things such as share transfers and directors' decision making. And whilst the shareholders agreement isn't necessary, it is a useful tool to set out the rights and restrictions that you may not want to be made public, and the two documents often work in tandem. So bespoke documents can help provide for future planning. For example, if there is share transfer restrictions, a company's articles may also provide for permitted transfers, allowing transfers between spouses or civil partners, children and grandchildren, without the usual transfer restrictions applying, which can be useful for tax planning purposes. The company's articles and shareholders agreement should also provide for circumstances where things might turn sour. So whilst you may not want to go into a marriage or civil partnership thinking about the worst case scenario, it is useful to set out expectations from the outset, so that there's an agreed process agreed upon with clear heads if things go wrong. So taking the permitted transfers example, well-drafted provisions will also include a requirement to transfer shares back if a permitted transferee no longer is a permitted transferee, for example, on a divorce or a dissolution of a civil partnership. So Alex, what happens if a marriage breaks down?
Yeah, thanks, May. So there are a number of things that a court would want to consider when determining how business assets should be divided and reflected in a fair financial settlement. And this is when there's not necessarily a nuptial agreement in place. So first of all, it's important for the court to understand what a business is worth, what income it can produce, whether it should be producing more, what the liquidity in the business is, and whether there are assets realistically available for distribution. The court may also require specialist tax expert advice to work out the most tax efficient way of extracting funds to potentially fund a lump sum to the other party. And as part of the disclosure process, businesses or business interests will need to be valued. And this can be quite a complex exercise. And so usually a single joint expert, often an accountant, would be appointed, and they would be appointed by the court, but both of the parties would have conduct of the instruction. So then, as part of the disclosure exercise and also the process of instructing the expert, a business owner is expected to provide all relevant financial information regarding their business in a Form E, which is a financial statement for the court. And in that, obviously, the owner should be transparent in the Form E, as well as with the expert, about their predictions for the business and any assumptions surrounding future performance and income, but also any potential liabilities as well. So, for example, if there's a significant tax liability due in the next couple of years. There will be a number of documents to provide, for example, management accounts for the last few years, forecasts, recent sales and profit figures, minutes of any board meetings. And so once the expert is instructed, has reviewed all of the documents received, and then conducts their analysis, then they will provide a valuation for the report, or for the court. And that report will have either a single sort of value or a range of values. And at that point, both parties can then raise questions on the findings, including the methodology that the expert might have used. And these business valuations can obviously vary completely depending on the sets of assumptions that are relied upon. But it's important to realise that the valuation the expert provides is only a guide for the court rather than an absolute, and the court retains complete discretion. So it may well either ignore the expert report, that's probably unlikely, or it may disagree and think it's worth slightly more or slightly less. The next point to consider is the matrimonial and non-matrimonial nature of business assets. Assets which were acquired prior to the marriage and then kept entirely separate throughout the marriage are unlikely to be treated as matrimonial property unless required to meet one party's needs. But if business assets have been acquired or built up during the marriage, they may be considered to be matrimonial in nature, and then the starting position would be an equal sharing of those assets. So careful consideration should be given to the work undertaken by the business owning spouse pre-marriage and post-separation, and what difference this has made to the business and therefore its value. So a spouse could be accruing post-separation non-marital assets immediately from the point the parties separate, rather than at the point of a divorce or even the start date of a trial. Another point to consider is that the passive growth in a business could be argued to be part and parcel of the matrimonial element of the business. So, for example, a wife who has been supporting her business owning husband to pursue his business endeavours throughout the marriage, that passive growth element could be considered matrimonial, as she made a significant contribution to that. So assessing what is matrimonial and non-matrimonial nature is vital in cases involving businesses, as the non-business owning spouse may have a weaker claim against the value of the business in circumstances where the value was generated either before the marriage or following a separation. So what's the court's approach, and what can the court order? Well, family judges have quite a lot of discretion when determining the division of assets. So they can either take a formulaic or a more broad brush approach. It's not a sort of black letter accountancy exercise at all. And the court will apply the concept of what is fair. So the court's not restricted to a single way of determining what is matrimonial and what's non-matrimonial. So if a court determines that one party's made or will be making significant contributions post-separation towards increasing business value before its sale, then that might result in a greater share to that spouse. But how can certain businesses be divided or shared? Because they're not cash equivalent. They involve a lot of enterprise risk, and a lot of illiquid capital is locked into a business's value. Well, firstly, the court is unlikely to order a company to transfer or sell assets, because obviously such assets are owned by the company and not the spouse. So, and also the company is not usually part of divorce proceedings. And the court is also unlikely to order a sale of the company altogether, because that may well destroy the party's future income source. So what to do? And there are a number of options that the court has, and they can be quite creative in the solutions they put forward. So first of all, they could apply what's known as Wells sharing, which is following the case of Wells and Wells. And that's when the court divided the assets in specie to provide each party with a share of illiquid and illiquid assets. They can also apply a discount to illiquid assets or to minority shareholdings. But then it does mean that both parties hold shares post-separation, and it would be a transfer without liquidating them. But in applying this, then both parties share in the ups and downs of the business going forward and would then share the risk as well going forward. Alternatively, the court can order a transfer of shares between parties. So shares in a limited company can, in theory, be transferred as they constitute property under the Matrimonial Causes Act. In quite rare circumstances, the court can award non-owning spouse an award in shares, which is not an ideal, as parties remain tied to each other, but it is an option if it's completely impossible to value a business or that it remains entirely illiquid. And one of the points I think May is going to talk about is third-party shareholders, and they might be reluctant to agree a share transfer between spouses. So you might have to look to an alternative way of meeting the other party's claims. So, for example, the fixed value of shares in a company can be offset against other non-business assets. So one party will retain the business and the other party will receive a lump sum to reflect the value of their share, or a deferred lump sum equal to the percentage of a net proceeds of sale. And that avoids an actual transfer of shares, but it gives credit for potential that shares could be worth more in the future. And now over to May.
Yeah. So before any settlement is agreed or any draft order is submitted, the parties should take into consideration provisions of the Articles of Association and any shareholders' agreement, because these documents may already set out provisions that apply in the event of a divorce or a dissolution of a civil partnership. So, for example, there might be provisions requiring an ex-spouse or ex-partner who has been transferred shares in the course of marriage or civil partnership, which is ended, to transfer their shares back upon divorce or dissolution. And the articles might set out kind of other binding terms, such as the price at which shares are to be transferred back. So these might be, it just depends on the mechanics of the company's articles, but it might be that it provides the transfer price to be agreed between the parties, or to be set on, for example, market value, or to be the price paid for shares, which is unlikely to be very much if shares transferred between couples, or be the aggregate nominal value, for example. And when the transfer price is based on market value, we would usually expect to see valuation mechanics within the article, setting out who the value is going to be and what factors the valuer should take into account. Things like assuming the business has been carried out as a going concern, there's an arm's length transaction between seller and buyer, and taking into account any minority discounts, for example. The company's articles might also set out the share transfer process and contain provisions around timings and preemption rights, which are essentially rights requiring shareholders looking to transfer their shares to have to offer them to the existing shareholders before they can transfer them to a nominated buyer. And if the shareholders' agreement and articles haven't been taken into consideration during settlement negotiations, and it comes to light that whilst an order has been made, affecting that order might be slightly trickier due to things like preemption provisions on transfer, or the article setting out a fixed transfer price. And any variations to the existing provisions will require consent of the other shareholders. So a shareholders' agreement is likely to require all the shareholders to agree to any variation to the provisions under that agreement. And any variation to the Articles of Association will need at least 75% of the shareholders to agree, which creates more hoops to jump through to kind of get where you want to get.
Thanks, May. So just drawing it all together, I think it's important, obviously, for family lawyers and corporate lawyers to work together in tandem, whether it's through drafting nuptial agreements or whether it's during a disclosure process within the context of financial remedy proceedings, or indeed the valuation process and instructing the expert, to ensure that there's consistency and also to protect a client's commercial and financial interests. I suppose the other point to raise is also to keep these shareholder agreements or nuptial agreements under review, particularly following a big life event or a key corporate event. So having sort of a joined up team where everyone's on the same page and we're sort of working through a case together is probably really beneficial for a client. And I think that's our presentation. I'm just going to hand over to Lottie to see if there are any questions.
Sorry, muted. Thank you so much for that overview. And I think as particular importance is actually having the right team around you working together to get the best outcome for the clients is essential, no matter what, whether there is a business or not. One question that has popped up is wondering how you can ensure company documents through the disclosure process remain confidential.
Yes, so during financial remedy proceedings, there is an implied duty of confidentiality. But obviously additional safeguards might be required and advised. So for example, asking the other party to enter into a confidentiality agreement before exchanging disclosure. So then there's the sort of option for one party, if there is any breach, to potentially sue the other party. However, with nuptial agreements, so when sort of pre-marriage, there's been no marital breakdown, there isn't an implied duty of confidentiality. So in those situations, it's imperative that both parties enter into a confidentiality agreement if confidential company documentation is being sort of disclosed, and that also might be a requirement of the other third-party shareholders as well.
Okay, that's helpful.
Have a look at the shareholders agreement, because that would usually contain confidentiality provisions, but it usually also contains carve-outs for where you're required to disclose confidential information about the business under a court order or by law, for example. So have a look at your contractual obligations over there as well.
Cool, thank you. One other one as well is, does it make a difference on the formation of the business, i.e. whether you are a sole trader, whether it's a limited partnership, or whether you are a shareholder of a public company?
May, do you want to answer that?
Yeah, I mean, it all forms part of business interest that you have. Because limited partnerships and private companies are incorporated, they're considered separate entities, and they might have other people involved, so other people being directors or other people being shareholders, which would normally mean that there could be other people involved in the decision making. So providing information about the company's annual accounts and things like that might involve other people. But from a family perspective, it all forms part of their assets, doesn't it, Alex?
Yeah, absolutely. And that's why, in terms of drafting nuptial agreements, obviously you can include whatever you want as long as it's agreed in the definition of separate property, and that would obviously take into account how the company is held.
Perfect, thank you. Last but not least, how might a single joint expert value the company? We're talking a lot about valuations. How do you actually go about that for this purpose?
So I think it would depend on the nature of the business, but commonly valuation methods usually adopted is on capitalized earnings, so calculating the worth of the business's anticipated profits based on current earnings and a company's expected future performance, or a net asset valuation. But obviously there can an expert can take into account discounted cash flow valuations, which may show some trading losses. And that can be used in conjunction with valuations based on earnings or asset basis. So there's a variety of methodologies, but that's, I would say, probably the most commonly used.
Yeah, and then at what point would that valuation take place? Is it at the point of separation? Do you know what I mean? Because sometimes it can take a long time to actually get divorced. Suddenly maybe you've got a huge uplift in the productivity of the company, and it's a little bit further down the line. Where does that snapshot of valuation take place in the process?
So that will be obviously a point to discuss, because it may be in one party's interest to want the valuation at the point of separation. As, if there's been a particular growth after separation, the other party might want it later on. So that is a point to sort of agree within the context of the letter of instruction to the expert. But what I found is often happens is asking the expert to say, well, what's the value at point A when the party's separated? What is the value at, a year later when the party's divorced? And then it will be presenting both figures to the court, and then the court would exercise its sort of discretion to work out what would be fair. So there is slight flexibility, but again, it's just a point to negotiate, because each party is going to have a different
priority
fair in terms of when the business is valued.
And the articles might even set out a fixed date. So if there's kind of deemed transfer at a certain date, then that might be the date that valuation needs to take place then.
Brilliant. Gosh, well, thank you both so much. That was incredibly enlightening and educational and brilliant. So if anybody does have any questions or would like to follow up, please feel free to get in touch directly or come to me, and I will signpost you to Alex and May. But thank you again for everybody watching, and for both of you for being so brilliant. Thank you so much.
Thanks very much.
Yeah.
Thank you. See you later. Bye.
Bye.